This presentation was recorded at York University in October 2018 as part of the Court Organization and Management course.
If you'll remember a few weeks ago when we looked at Carl's article that he wrote with his wife, Ellen, about models of adjudication. And at that point I mentioned how his models of adjudication really were almost like a macro look at case flow management. And I thought because of that, this would be a good place to start this evening, because really I do think that there's a lot to be discovered from these three models of adjudication. The decisional adjudication. This is where the court applies readily known principles. This is probably, this may be equated to less complex cases where there are possibly one or two issues at stake. They wouldn't be overly complex cases. There's a procedural adjudication where the court chooses among principles that are predefined. And this appears to look like it could tend to apply to more complex cases, larger cases, possibly cases with more defendants, more issues at bar. And then you have the diagnostic adjudication, where the court defines, develops, and designs principles. And this is by far the most complex. And this would be those large cases, the Trans-Canada Pipeline case. Those sorts of cases would be the ones where you would get into diagnostic adjudication. Now, I believe that, having read Carl's article, that this could be used to speak into differentiated case flow management, which is what Steelman talks about. I'm not sure if it's a completely one-to-one ratio, whether it's a direct connection between the two, but I think that there could be an argument, and there may be a requirement for more research, but I think there's an argument for the fact that the models of adjudication and Steelman's differentiated adjudication could speak to each other quite well. If you look at Spielman, he says he has three tracks: the expedited track, the standard track, and the complex track. And when you look at that, it's the expedited track, they move quickly and there's very little need for judge involvement. To me, I can draw a connection between that expedited track and that decisional track. I would imagine that if a case is on a decisional track, you're going to find that there's not going to be a lot of need for the judge to get involved at that pre-trial stage. The standard track requires judge involvement, conferences, hearings, but they're not exceptional. This would be, just as it says, a standard. And I can imagine that that would fit very well in with procedural. And then the complex is those rare cases that require extra judicial attention. And to me, those types of cases sound very much like they would fit into the diagnostic adjudication track. But as I said, as far as right now, other than my sort of like anecdotal and experiential findings, there would have to be study. There would have to be research done into it, because my concern is that there could be diagnostic type cases that may fit into the expedited track. An example could be a situation like the stay of the Doug Ford, the Ward's decision, as if you want to call it that, where the Court of Appeal of Ontario heard a stay motion. It was very well expedited. It was extremely quickly done. But at the same time, it kind of fell into that diagnostic sort of model. So I think what we'll see is there could be a correlation, but it may not be a direct correlation, or it may not be a perfect correlation. But I think that it's worth looking into and doing a little more research and study into that to see just how great that correlation is. Now we're going to delve a little bit more into actual case management. And in Miller and Barr, they talk about the principles of successful coordination of case processing. Judges take collective and individual responsibility for the flow of cases. I'd like you to remember that, because as we go along this evening, you're going to hear some conflicting things as to just how important that is. But I believe it's fundamental. As Ian indicated earlier, when there's delay involved, the parties, the players, the participants in the proceedings, whether they are prosecution, defense, the judge, the police, the court administrators, they're all blaming everybody. When I was in Jamaica, Chief Justice McCallum was famous for saying, let's not blame everybody, let's not blame each other, there's enough blame to go around. And I think that's the approach that we have to look at. There's enough blame to go around for the delay, but it's the judiciary that has to take responsibility for overcoming that delay. There has to be continued consultation among the judges, court staff, and the bar. I think that's pretty clear. Establish standard procedures. I agree with Miller and Barr that there has to be standardized procedures, but I would suggest that those procedures have to be flexible enough to account for the differentiated adjudication or that we talked about just a second ago. If you have too much rigidity, I think that can hamper case management, and we'll see that later. Centralized judicial responsibility for court case flow. That centralized responsibility is with the court and with the administration. That's fairly clear. I don't see anything in case management, with the exception of the Winkler article, that suggests that responsibility should be anywhere but there. Case processing time standards. Time standards are extremely important because they benchmark. They give you an indication as to how long things should take. Without those time standards, you really don't know. You really don't know what to expect case to case. So time standards are important. They keep you on track. But at the same time, I would say that to a certain extent, even though you have time standards, there has to be some flexibility to account for the different cases. You continuing measurement of performance, absolutely. In my work in Jamaica, we measured performance, and we measured it every 6 months to see if we were improving. Because if you continually measure performance and you find that you're not improving, then you can adjust. If you don't continually measure your performance, you can't adjust, you can't make corrections on the move. Case flow management systems modified to meet the changing conditions. This is absolutely fundamental as well. If you imagine that you set up a case management system and you have 10,000 cases, and then 5 years later, you have 15,000 cases. Do you think your case flow management system will work as well with 15,000 cases if it was designed to handle 10,000 cases? It may, but it may not. And that's why you have to continually look at it and modify it if necessary. One of the reasons why it may not is there's a very good chance you're going to have fewer resources. So you'll have more cases and fewer resources. So you have to become more efficient to remain effective. Case status monitoring from institution to disposition. We call those milestones in our court. We have 3 milestones, and we monitor at those 3 milestones. And if the parties are not where they should be at those milestones, we send out what we call a notice of status review, and they have to justify why the proceeding should not be dismissed. So there's 3 stages in a proceeding where if they don't meet those milestones, they have to justify why it should continue. Very important, because when we started doing that in 1998, we had so many status reviews because the parties weren't used to it. Now, they're used to it. We don't get nearly as many status reviews as we did when we first started, because the parties now expect that they know that this will happen. Techniques to monitor lawyers' scheduling conflicts. This is one of the things Carl, you'll have to forgive me. That's really difficult. I think what you have to do is not, maybe what's meant here is you have to make sure that you don't add anything to ensure that you are not causing lawyers scheduling conflicts. I'll give you an example. When I started working in Jamaica in 2013, they had a trial credibility rate of 22%. That meant for every 5 trials that were set down, roughly 1 proceeded. They also had a situation where lawyers were triple and quadruple booking themselves. So you would have a case called, and the lawyer, somebody from the lawyer's firm would say, "I'm holding for the lawyer, he can't be here." Right? Frustrated the court. And I said to the court, "But what really can we expect? A lawyer has to make a living. He's reasonably certain, because you only have 22% trial credibility, that the matter's going to be adjourned. He's going to play the odds. And these lawyers are pretty good at playing the odds. They know that if it's the first time in court, it's going to be adjourned. So they won't show up." I said, if you can increase your trial credibility, you will get rid of the problem of the lawyers double and triple booking themselves. So we worked at it. In 2018, their trial credibility is now 78%, and the problem of lawyers double and triple booking themselves is disappearing. They didn't have to do anything. All they had to do was make sure that the lawyers knew that when they appeared in court, a substantive, meaningful step would be taken in the proceeding. That's all it took. So there are certain things that you can do which help your efficiency, reduce your delay, but also do things like keep lawyers from scheduling conflicts.
Yeah, it sounds like a good illustration of that principle. You're putting it in.
I think it is. Is that what you were getting at in that point, Carl?
Oh yeah, that's the whole thing. You have to create expectations that will reduce the possibilities or the incentive to engage in these activities. And there's a whole one of the famous ones that Ernie Friesen always talked about was short scheduling. He used to argue that you should make sure that significant events occur at tight enough intervals that a lawyer doesn't have to go back and review the file again 2 months later at additional cost to the clients. You can do it maybe within 2 weeks. So a variety of things that he would push for. And a lot of them were designed not for the convenience of the court, but to facilitate the effectiveness of counsel, which in turn the court can use to convince lawyers that it's worthwhile to give the court a larger role in the scheduling process.
You know what, I completely agree with that, but there has to be a balancing act. And the reason I say that is because what happens is if you schedule too frequently, then you get situations where the number of hearings that it takes to move a case along becomes so large that the increase in the efficiency by shortening the time is actually detrimental because you're increasing the number of hearings and you're plugging up courtrooms. An example of this, and I'll apologize because a lot of my examples with respect to case management come from, not from Canada, because as Ian so graciously said, our court gets it. We are very good at case management in the federal court. So I don't have a lot of examples from our court of bad case management, but I do from Jamaica. So in Jamaica, what's happening was they have something called the gun court. You look at it from one perspective, it's a very well-run court. Their clearance rate is almost 100%. They can get rid of so many files in a reasonably short period of time. None of their files are older than 4 years, which is very good. But in the first term of 2018, they disposed of 110 files, which is right on track. It took 1,500 hearing days to do it. So if you have 1,500 hearing days to dispose of 110 cases, and that's only in one term, that's in a 4-month period. That's an enormous number of hearings. And what happened was, to get rid of those 110 cases, it took 4 courtrooms to get rid of 110 cases. If they had had fewer adjournments and and just only had meaningful hearings where substantive work was done to advance the case, they probably could have done that in 2 courtrooms instead of 4, and those 2 courtrooms could have been freed up for other cases. So you get to that point where it tips, and for the individual case, it works very well to move it along, but the effect on the entire organization is that you plug up courtrooms in the effort to move the one case along. So, core features of successful case management. This is Steelman. Now remember, Carl and I can't remember his first name, Miller.
Harry.
Harry Miller. Wrote their book in 1981. Steelman wrote his article in 2008. Look at the similarities. Effective leadership. Carl and Miller said the same thing. Relationship between chief judge and the court manager. They were getting at the same thing. Time expectations. What's reasonable for a citizen to expect? Miller and Barr were saying the same thing. Court control of case progress. Same thing. Credible trial dates. Same thing. Nothing has changed. And that's the problem. Nothing has changed. We still have delay. I'm going to talk about some statistics in a few minutes that when I realized, it just blew my mind. Nothing has changed at all. So Miller and Barr talk about control of the process. The court does not face a caseload crisis, but faces an appearance crisis. 1981, they said this. In that courts could handle the caseload if they could cut down on the number of appearances per case. That's exactly what I was talking about with respect to gun court in Jamaica. And we see it here. In 1985, and Carl, I found my paper. 1985, I did my master's degree, and I wrote my major paper on this very issue. And the court at the time, I did a very specific section of the Supreme Court of Ontario. The court at the time didn't have a caseload problem. They had an appearance problem. And there were so many appearances to get so little work done. And it's still an issue. But I would imagine that you would find the same thing today. In 1985, when I did my major paper, one of the things that was the problem was I would go into the courtrooms and I would get there and I would sit down and I would be ready for a full day of court and they'd be finished by 11 o'clock. And I would think that in a lot of circumstances you may see the same thing today. It may not be 11 o'clock, it may be 1 o'clock, it may be 2 o'clock, depending on the court, but I would think you'd see the same thing today. My question is, how do you have effective case management when you're not sitting a full day? I think it's impossible. So the other thing that Miller and Barr said was that many judges persist in the belief that they are controlling the process because they are ratifying adjournments. And I think that today that persists. I think there's a lot of courts and a lot of judges where, I think the mentality is that the first appearance is automatically going to be adjourned. You don't even have to worry about it. You don't have to prepare it because that first appearance is going to be an adjournment. I think that is something where it's become almost ingrained. It's been happening for so long. And then you get to Steelman. All these years later, balance need to complete steps and conflicting demands of the participants. So you've got to realize that there are steps that you have to complete in a proceeding, but you have to make sure you can accommodate the busy schedules of the lawyers, the judges, the witnesses, all the players. And that is one of the things where predictability is so important. Consistency is so important. Advanced timing is so important. If you can tell a witness that they're going to be needed in court on the 18th of October, 6 weeks ago, you'll have a much better chance of them coming than if you adjourn, and then last week you say you need to be in court on the 18th of October. So you have to balance that. You have to make sure that the steps are taken, but you have to really look at the conflicting demands of the participants. And you have to allow enough time for the completion of the necessary steps. This is another thing in Jamaica. What they were doing was they wanted to make sure that the lawyers didn't forget about the cases. They wanted to make sure it was at the forefront of their mind. So what they do is they'd adjourn a pre-trial step for 2 weeks. They'd adjourn it for 2 weeks, even if it was a step that was going to take 3 months. So instead of adjourning it for 3 months and having a meaningful hearing 3 months later, they had 6 hearings in the 3 months, all of them adjourned. How can that be meaningful case flow? Now, you can say that's Jamaica. The same thing happens here. The same thing happens here. I have a friend who was unfortunate enough to get on the wrong side of the law, and it wasn't even a major offense. And we kept in contact because I'm in the judicial system, and he kept on saying to me, I'd give him a call if I knew he had a court date coming up, and I'd say, what happened? And he said, it was adjourned. I said, really? Again? Yeah. It was adjourned. He had 10 court appearances before he pled guilty to a lesser charge, and there was no court time. There was like 3 months parole. That's it. 10 court appearances for an offense where the end result was 3 months on parole. Crazy, crazy.
Incidentally, Bruce, one of the classic works on criminal case processing in the U.S. is a book by Malcolm Feely. It's a wonderful book. It deals with all different aspects of the criminal justice system, but the title of the book is "The Process is the Punishment."
Yeah, and it's true. It's true. I've been to various jurisdictions, and you'd be surprised how many people are in the court system for longer than their sentence. I was in one courtroom where the judge said, okay, the maximum sentence is 18 months, but you have been in custody for 3 years, go home. And that was the end of the trial. That's how the trial ended. And that process is the punishment is a very good way of putting it. Does anybody have any questions about what I've said so far about the process or the case management or anything like that? Kayla?
More of just a comment, but so I'm coming from an administrative, so it seems like it's kind of a balance between those two kind of extremes to get the right.
Yeah. Well, and it's I think you were going to say to get the right balance.
Yes.
Yeah, and that's exactly what it is. And that's why the constant monitoring, and that's why the statistics and the data are so important. Because once you monitor and you get statistics and data, you will determine how many cases settle, how many cases proceed, the average length of cases that proceed. And so what you can do then is you can say, okay, we set one in the morning, one in the afternoon, but we know that one of them's going to proceed, one of them's going to settle. So you set 3 down instead of 2. Or you can set down 6 for a week, and you can say to 2 of them, and we get to this, they call it shadow court. You can call it various different names, but you can say 2 of the cases, you're going to be heard this week, but we're not exactly sure which day. And that's more difficult, rather than setting 3 down for a day and then here, and then instead of 2. Now the problem is, what do you do if both of them proceed and you can't get to the 3rd one? Statistically, you might find that is such a rare occurrence that you don't have to worry about it. If you have a settling rate of anywhere near 50%, then you can set 3 down a day and you don't have to worry.
Incidentally, Bruce, another aspect to this is something that I tried with the Immigration Appeals Tribunal, and this is more a function of having the space but not having the personnel, the adjudicators. But so I'm not sure if this applies in Kayla's situation. But it was something Friesen referred to. He talked about the principle of the idle judge. And I found that they actually applied this in Montreal in their superior court, because the judges would have a judgment week. They'd be sitting full-time, hearing cases for a couple of weeks, then they'd have a week off at that time, to write their judgments. That time they were so generous in the Cour Supérieure that they were given 2 weeks off for where they didn't have scheduled sittings. But then the Chief Justice at that time knew that he had a lot of cases piled up, and he wanted to give out more trial dates. So what he would do was tell the judges who were sitting preparing judgments that if they were willing to be available, if they would do their judgment writing work at the courthouse and would be available if the need arose, that he would schedule an additional trial dates as long as they were available. So if if 2 judges wound up being occupied, they could schedule that 3rd trial in front of one of the judges who had no responsibility sitting that week. And the judges looked at that and said, well, if we come in and we're available for that work, like supply teaching, as long as you give us credit toward holiday times and stuff like that, we'll do it. And so sometimes they would come in even when they weren't doing work preparing judgments, because they knew that there was a possibility of them getting some extra credit which they could cash in the future. And it wound up, if you're talking about going from 2 cases to 3 cases, that's a 50% increase in the dispositions that would be available without any additions in the number of adjudicators. So this principle of the idle judge can sometimes be a very simple technique, but it's, as an example of looking at the problems you've got and the resources you've got and figuring a way to enhance your capacity without additional costs and without expecting people to work beyond what's been considered an appropriate workload.
That would work very well if you have an extra hearing. So if you had 3 cases and all 3 proceeding, you had somebody who was not sitting and you had an extra hearing room, that could work. We have done that in the past when we were in the mid-90s. We were going through a horrific period of time, and we would just split a list and have 2 judges instead of 1, and it would work very well. But we had the extra courtroom. So up until now, we've been talking about sort of the pre-trial aspect of it and the number of hearings it takes to actually get to the trial. And there's a lot of situations where the number of adjournments and the number of hearings to get to trial is absolutely absorbent. Carl talked about the Justice on Target program, and when they started the Justice on Target program in 2007, I believe it was, they had, I think it was 9 or 10 pre-trial hearing dates prior to the trial actually starting, and they wanted to reduce that. 9 or 10 is significantly too many. As Ian said, in our court we do a very good job of case management. In our court we're down to probably 3 pre-trial hearing dates. But they're meaningful, and every time a file goes into court, substantive work is done towards advancing it to trial. We don't have any adjournments. The other thing our court does is if you have a trial date and it's set, you have to do a formal motion for an adjournment, and it has to be filed and served in advance of the commencement of the trial. So we get very few adjourned trials by the parties because they do not want to have to do a motion in advance of the commencement of the trial. If you can just show up on the first day of the trial and say, we're not ready to proceed, and the judge grants you an adjournment, there's no disincentive. We didn't have to say anything about there not being trials adjourned. All we had to do was say, you have to file a motion. But now we're getting into trial management. And Steelman says trials consume a great deal of judicial time. And they do. They do. The preparation for trial, the writing of the judgment, the hearing itself. What about the preparation of a trial and it settles? Because the judge still has to prepare it. And then the party comes in at the first day of the trial and says it's settled. All that judicial time has been wasted. Judges and attorneys find no lack of fairness when trials are conducted more rapidly. So that leads me to a question. If there's no reduction in fairness, if the trials proceed more rapidly, why don't they? Why don't they proceed more rapidly?
Lawyers.
The natural scapegoats, absolutely, the lawyers. But then you get situations where sometimes not proceeding rapidly is actually a benefit. Automobile accidents. They are notorious for taking a long time. But that is the one case you actually don't want to speed up. So there are certain things where for justice to be done properly, it takes time. Now the problem in Ontario is, even with no fault, with so many motor vehicle accidents going through the court system, and you have to take time with them, that's an enormous amount of judicial time. It's delay, but is it a denial of access to justice? Maybe not in that circumstance. But in so many other cases, because of those insurance claims that are delayed, maybe it is a denial of access to justice. So it's a really complex issue, and each case has to be looked at on its own. The other aspect, is, the last one on this slide, is that steps can be taken to manage the trial. In our court, we are very proactive with respect to that. Before the trial even starts, if it's a long trial, there is a schedule so that we know what day the witnesses are going to be called. And that witness knows that they're going to be called on that day. And we have enough experience, or the judges have enough experience, I should say, to know that they have to allow a certain amount of time of leeway to account for an extended cross-examination, that sort of thing. Very rarely does that trial schedule fall apart. The judges have enough experience that if a witness is going to be called on a specific day, they are ready on that day. Occasionally you do have situations where the witness might not get called until 11 o'clock, but they are called. Occasionally you'll have a situation where the previous witness finishes early the previous day and you have some downtime for the afternoon. But for all intents and purposes, it's very well managed. And managing the trials is so important. We have situations where in pretty well every trial, the judge says, are there any motions? And they'll hear the motions at the beginning of the trial. They'll take the first half day and they'll hear all the motions that relate to the proceeding of the trial. So they manage their time very well. And that's one of the things that can be done to alleviate that.